What happens if a defendant skips small claims court? Imagine you're in a small claims court, ready to settle a dispute, and suddenly the defendant doesn't show up. What happens next? Well, the court has a clear process for this situation. If the defendant misses the scheduled court date, the plaintiff can ask the judge for a default judgment. This means the judge might decide in favor of the plaintiff without hearing the defendant's side. But before that happens, the court needs proof that the defendant was properly notified about the case. This usually involves showing that the notice of claim was served correctly. The plaintiff might also have to provide evidence and testimony to support their claim. From the courtroom perspective, the defendant's absence means they lose the chance to defend themselves or dispute the claim. Small claims courts are designed to be simple and quick, so if the defendant does not appear, the case moves forward based on the evidence presented by the plaintiff. There are no criminal penalties like jail time for skipping court. Instead, the main consequence is a civil judgment against the defendant for the amount the plaintiff claims. This judgment can be enforced if the defendant refuses to pay voluntarily, through actions like wage garnishment or bank levies. If the defendant has a good reason for missing court, such as illness or an emergency, they can ask the court to set aside the default judgment or reschedule the hearing. But they need to act quickly and provide proper documentation. Overall, skipping small claims court usually means the defendant loses the chance to contest the claim, and the court will likely rule in favor of the plaintiff. This process makes small claims courts a straightforward way to resolve minor disputes efficiently.